right, and hi, and welcome back. Attorney Steve BitTorrent, bringing you another exciting video here in the field of BitTorrent litigation. We're talking strike three holdings, and we are talking default judgments. So this video will hopefully answer the question of, well, if I get a subpoena from my ISP, like Charter, Spectrum, or AT&T, Verizon, whatnot, Cox, Comcast, in regard to a strike three holdings file sharing lawsuit, what if I don't answer? What if I don't care? What if I don't care? Will they just go away? Well, this might shed some light. This is general legal information only and not legal advice. But here is a default. This is filed by the Ban Law Firm. This is one of the major law firms that handles these cases for strike three. This case is filed in the United States District Court, Central District. This is a rare one in the Eastern Division of Riverside. I don't see a lot of cases out there, but you have the case number here. I'm not going to go over the John Doe, but however, it looks like the John Doe will be identified. Why? Because of the default, because somebody needs to go and enforce a judgment now. That's our next step, to enforce this judgment. But what happens is if you don't answer the complaint within the time frame, usually it's 21 days from the time you're served, the plaintiff can move for a default, and then the clerk will enter the default if there's no answer, and then they seek a default judgment. That's what this is here. Along with the default judgment comes a motion for a default judgment, citing the cases and authorities and things like that, the memorandums of point and authorities. It was all in there. I'm not going over that today. I wanted you to see what a proposed order looks like. This was a proposed default judgment and permanent injunction. That means the downloader, movie downloader, sharer, whatnot, cannot do this anymore. So the Honorable Judge Terry Hatter, Jr., and this is a pretty quick thing. You'll see here, this cause came before the court on the motion for default and permanent injunction filed by the plaintiff strike three holdings. Having considered the motion being otherwise duly advised, the court hereby finds, maybe we need to go down here and do a continuous scroll. That might help us out. Okay, so let's go here. The defendant's name is redacted, but the court did enter this judgment. This order that they were seeking was entered by Judge Hatter. And so the name, as I mentioned, I'm not going to mention here for privacy reasons, but the name is going to be posted so they can, I'll talk about that in a second. Anyway, so the court went through. I'm not going to go through all this mumbo for you. You can check it out if you want. But here's what they're looking for, ordered and a judge. Now, again, this is a proposed order. The judge didn't have to sign this. The judge could have said, I'm not going to give you what you're asking. But $35,250 is what they were seeking in statutory damages. Now, you may say to yourself, this is a common question. Well, I didn't cause that much damage. What did they lose, a $50 subscription? I mean, how did they get to $35? It's called statutory damages under the copyright law. And this is why I'm doing copyright law, because it has a lot of teeth, and you have to be very careful with this law. So they're seeking the $35,250. As I mentioned, the judge did enter that award, and enjoining them from contributorily or indirectly infringing. So that was issued, and there it is, very simple, done and ordered. The judge will sign it, becomes an order, and so now they would have a signed judgment for $35,250, and I believe it also entered the cost. I'm not sure, actually. I think it was $35 here. But anyway, point is, and I think it was about 45 movies or so. So you can see what happens. I think it was a $750 per movie. So note that they didn't go for the full $30,000 statutory for non-willful. They didn't go for the $150,000 per title for willful infringement. So they just went for the real basic, try to make it easy for the judge, $750 a movie, and I think that's where this case landed. So that's what can happen. And then make sure you bookmark this video. I'm going to be doing a video shortly on collection. Well, how do attorneys go and collect judgments? We'll talk about that. They can levy bank accounts. They can garnish your wages. They can even call you in for a debtor exam. But watch that video. I want to get more in depth on that in that video. But there it is, strike three holdings. There's a recent update. You can see if you don't answer the complaint, depending on your movie count, you could be looking at $750 or more per movie, plus cost, fees, and whatnot. So there it is. That's a default judgment, strike three holdings. BitTorrent litigation updates. Make sure to bookmark us for future updates. Hope you guys are all off to a great week. Happy Monday, and we'll be back. Take care. General legal information only, not legal advice. Bye now.